A lot has been said in California about criminal justice reform by politicians, by the current Los Angeles County District Attorney, George Gascon. And one thing that I'm not hearing is what we can do to make sure that dirty cops and dirty prosecutors, because both exist, make no mistake, no matter how pro-cop you are, no matter how pro-prosecutor you are, there are dirty cops, there are dirty prosecutors. And so this video is about 3 simple things that those politicians, if they actually want criminal justice reform, should be doing, should be looking for, and should have in place. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be talking about 3 things that if the governor, if the legislators, if the politicians want fairness in the criminal justice system, they should enact right now. So anyway, let's dive right in. Number 3 is I think that there should be body-worn video. That police officers should be required to turn on the little cameras that they are given that are on their lapels. They should be required to do that for the entire interaction, and they shouldn't be allowed to testify about anything that occurred outside of body-worn video interaction. I mean, why would they be able to? They can simply turn on their camera, and so now we don't have to rely on their memories. I mean, how many interactions do they have with people per day? How many cases are they witnesses in? We know that we really can't rely on their memories for these things. So we need to rely on the body-worn video. And if they were not able to testify about something that they claimed that they saw or that a witness said without body-worn video, then we would eliminate a lot of errors, exaggerations, just them reading the police report a year or 2 years later and regurgitating it. We would eliminate so much of that, and we would have more justice. And importantly, this applies to witnesses who were interviewed. So if there's a witness who's interviewed, why wouldn't you turn on a camera? In this day and age, 2023, we all have cameras with us all of the time. I don't think the cops should be able to testify to the conversation with that witness if they did not turn on their camera. And secondly, I don't think that that witness should be able to be called, because we don't get to see what they said to the police. So if they said one thing to the police a year or 2 ago, here we are at jury trial, maybe it's a murder case, a really serious case, someone's life is at stake. I don't think that that witness should be able to be called when we can't see what they said originally. Number 2, and this is something that George Gascon could get on immediately, and he could make an office policy, but he has chosen not to. Hand over the discovery immediately to the defense team. So discovery refers to all of the evidence, all the police reports, video footage, witness interviews that are hopefully captured on body-worn camera, all of the evidence that they have against the defendant, right? The reason why they're prosecuting him, the evidence that they have, their whole investigation. If you want to hold somebody in jail, if you want to set their bond at thousands of dollars, sometimes millions of dollars, then at least have your file ready and let that person's attorney have a copy. I was just at court today for, I think, like the 4th time in a case. And in the police report, they talked about video surveillance. My client is happy to have the case go on for, a lot longer if necessary. That's fine with him. He's out of custody. But it took 4 court dates to get a copy of the video. So many excuses. I've heard from the prosecution, somebody who is under George Gascon, hey, I don't have my file. Oh, we don't know if we have that yet. It's been about 4 months. Why wouldn't they hand everything over immediately? How are you prosecuting something without even seeing the evidence against the defendants? That's really the disturbing part of that. And that is something that George Gascon has not fixed. He hasn't taken any steps that I have seen whatsoever to fix that. And now, number 1, the prosecution should not be able to withhold evidence and still use it at the last minute. This is inspired by a case that I had where what happened I felt like was shocking, and it worked out for the client in the end. We won the trial, but I was so upset. Okay, so it was a domestic violence case. My client's girlfriend was bullied by police into making statements against him when they had first come out and interviewed everyone, and she was like, nothing happened. They threatened her, saying that they were going to call Child Protective Services and potentially have her kids taken away if she didn't tell them what they wanted to hear. One of the officers then made a statement saying that her 3-year-old daughter was pretty, which to me implied that if she were to go into foster care, if she was going to be taken into the system, she could be potentially assaulted. Really dark freaking stuff, right? Now, in this case for, I don't know, maybe about 9 months before the case actually got to the point of being set for trial. And the whole time, we had seen body-worn footage of multiple interviews that the police had had with my client, who was the defendant, with the neighbors. What was missing was there was no body-worn footage of the alleged victim speaking to the police. And the alleged victim was completely on our side. She never wanted the case filed. She thought it was bull. The only reason why she ever said anything against the client is because they told her that they were going to take away her kids. And he agreed with that. He's like, you know what? I would rather go to jail. I'd rather be facing these charges than have our kids taken away and potentially put in foster care where who knows what's going to happen to them. So the whole time that this case had been going on, the public defender who had the case before me and I had both been told that there was no body-worn video of my client speaking to the police officers. Then 2 days before trial, the DA sends me a link to it saying like, oh yeah, I'm not sure if you got this before. Here's a copy of this body-worn video. He had said many times that it did not exist, not just to me, to the public defender. It was in our file. So I wrote, it's the eve of trial. I have so much to do. I'm working on questions for voir dire, which is jury selection. I'm working on my opening statement. I'm poring over all the evidence for like the 100th time, making sure I know it like the back of my hand. And I remember specifically being up past midnight, writing a motion to dismiss because I think that the case should have been dismissed. Why did they withhold this evidence? They had it and they didn't turn it over. They didn't turn it over for so long. I think that the case genuinely, it should have been dismissed. And the court said, well, I'm not going to grant your motion to dismiss, Ms. Barton, but I will grant you more time if you want to take the time to review it. My client, his family, they wanted to get this whole thing over with. They didn't want to extend it even more. And, I also knew that I could probably use it in my client's favor. But there was literally no punishment for the prosecution. There was nothing, literally nothing at all. How can that be? But I think what should happen is that if something is not turned over by a certain deadline, then the prosecution should not be able to use it, and the defense should if they want to. Because it wouldn't be fair for them to wait to turn that over because they think that it is not good for them. I hope you found this video helpful. If you did, please don't forget to subscribe, like, ring the bell. And if you do have a criminal case in California, feel free to book a consultation with me. You can find the link to book it down below. You can also find my number there.